So now we want to take a look at some of the common typical provisions you would actually see in the contract of sale. Very similar to the provisions we looked at in the agency agreement. Nobody expects you to memorize all these provisions. However, you do need to know what they are. They could ask you about, something particular about any of these provisions. So you need to at least know what they are. So let's take a look at them. Obviously, we have to identify who the buyer and the seller will be. Obviously, the seller would be the vendor. The buyer's the vendee. So, there's those OR and EE words again. Make sure you know who's who. We have to identify the property. The property description. I will tell you a very common mistake a lot of real estate agents will make in this section here when they're filling out this contract is they'll just put the address of the property and leave the rest of the information blank. That's going to get you in trouble. There's more information there. You need to put the legal description. The legal description meaning the lot, the block, and whatever the legal description is for that property. You also need to put the tax map number. A lot of times you hear it called the TMS number. and then obviously you do want to put the address, but you don't want to just put just the address. We got to make sure the address, the tax map number, and the legal description all match the same property. So there's no confusion on what's being bought and or sold. I'm just telling you, there's been a lot of problems in the past where agents just get lazy. They don't go look up all this information and they just put the address, and you're going to have problems. I promise you that. So fill out all the blanks. Fill them in rather. We have to agree on a purchase price. There has to be a specific price. You can't just put in there, we'll offer somewhere between $150 and $160. No, there has to be a specific price on what the buyer and the seller have agreed to. We have to agree on closing costs. Who's going to pay these closing costs? There are closing costs that typically the seller is responsible for. It's their cost. And then there's some other costs that typically belong to the buyer. We're talking about cost in addition to whatever you've agreed to in terms of sales price. The lender's going to charge fees. The attorney's going to charge fees. There's real estate commissions. There are a lot of different fees and costs associated with buying and selling real estate. Well, the question is, who's going to pay for this stuff? And I will tell you, typically, closing costs are negotiable. Okay, so basically, whoever agrees to pay. You could put in the contract that seller will pay their responsible closing cost. Buyer, you're responsible for paying all your closing costs. And that's fine. But it is very common, certainly in the market I work in, oftentimes the buyer will write into their offer that they want the seller to pay for their closing costs as well. So in other words, the seller's paying for their cost and they're paying the closing costs for the buyer. It is not unusual that a lender might put that as a stipulation in order to get loan approval. That the seller must agree to pay the buyer's closing costs, or at least some amount, or some certain amount. And by the way, if the buyer does ask the seller to pay their closing costs, they have to put a not to exceed amount in the contract. You can't just ask the seller to basically write a blank check. That's not going to work. So if you're going to put in there seller to pay buyer closing costs, then you must put how much of those closing costs going to be, or at least cap it at a certain point. Okay, but for the most part, y'all, closing costs are negotiable, and just got to work that out. So when will possession take place? And y'all, when we talk about possession, when will the keys be turned over to the buyer, where the buyer can move in and just take possession of the property? Y'all, that's what we're talking about there. And typically, it will be at closing. So once all the paperwork signed, we've closed, everything's done, then keys will be turned over and the buyer now has possession of the property. But you better read the contract, buyer or buyer's agent, because they may have put in the contract where possession will be 24 hours after closing, or maybe 48 hours after closing. I don't like it when that happens. I don't like doing that, but occasionally it happens. And I'm going to tell you, if the contract says 24 hours after closing, and that buyer shows up to the attorney's office or wherever the closing is taking place in their U-Haul truck, thinking they're going straight from there to moving in, and then find out they can't move in until 24 hours later, could have a problem there. So when does possession take place? Y'all, it's typically at closing, but occasionally it could be a short time right after closing when they actually get possession as well. So just make sure they understand when they do get possession. And then there's a provision called time is of the essence. Now, it's been my experience that means little to nothing to most people. But I will tell you, timeliness is a big deal, especially in these contracts of sale. Because basically what this provision is saying here is, time is of the essence. All the way through the contract, there are things that the seller must do. There are things that the buyer must do, in preparation for closing. And everywhere it says, buyer, you must do this, or seller, you must do this, it will also typically stipulate a time period in which you have to do it. Just for example, the contract may specify that the buyer has a due diligence period. A period of time to have a home inspection done, a termite inspection, heating and air inspection, you name it. This is their due diligence period. Well, you don't have the rest of your life to do this, buyer. It will usually stipulate in the contract how much time. It will put a date and usually a time in which this must be done. If you don't meet the timeline, because time is of the essence, then you have likely waived any legal remedies you may have had under that provision. So, for example, in this due diligence period, and let's say you had 10 days to do your due diligence, and you didn't get it done. For whatever reason, you did not get the home inspection done within the time period specified. Well, guess what, buyer? You've now waived your rights to go back and ask the seller to repair stuff, fix stuff, assuming they found issues with the property. You've waived your rights. In essence, you may be forced to purchase the property in the condition it's in because you didn't get it done within the time frame specified. So, I'm telling you, you better pay attention to all these time frames within the contract. Do not let that time frame expire on your client. Otherwise you're you're causing them to waive some legal rights or remedies they could have under this contract. So be careful with this. Again, the contract will specify or talk about personal property and fixtures. We know fixtures are personal property that's been attached to real property. And according to the law and the contract, fixtures are to stay with the property. Now, potentially, y'all, the seller, because y'all say they've got a chandelier in a dining room, and I'm not leaving the chandelier. Chandelier's been in my family for X number of years, and I'm not going to leave it. Well, first of all, if I were the listing agent, I would be telling the seller, well, then take it down now before we put it on the market. Take that chandelier down and put something back up in its place. That's the best way to handle it. However, could they just leave it up there, and then when they get an offer, they write into the contract, the chandelier and dining room will not convey or will not stay. Y'all, as long as, now I will tell you, that's a counter offer because you've modified that offer. And we've talked about a lot now. You better understand what you're doing when you make that counter offer. It'll be a whole lot easier if that chandelier was not an issue. Get rid of it. Take it down now if you want it to go, seller. But as long as they write in the contract that's whatever fixture you're talking about will not stay, and the buyer agrees to it, then you're fine. But if it hasn't been agreed upon by the buyer, then fixtures must stay. Seller, you cannot remove anything that's been attached to the property after it goes under contract. Once it goes under contract, it's staying. Okay. Now, in terms of personal property, we've already talked about this at least once or twice. But remember, personal property should not be included in the contract of sale. It's not a valid conveyancing document. Personal property must be written up on a separate document called a bill of sale. And then you can attach the bill of sale to the contract of sale. Okay, you just write it, you write personal property into the contract of sale, and the seller may have agreed to leave it, but you go to close and go to move in, and you find that they took whatever personal property you thought they were leaving, and you don't have a bill of sale for it. You probably have no legal grounds to do anything. You can say, but it was in the contract, okay? But I'm telling you, the contract of sale is not a valid conveyancing document for personal property. It has to be on a bill of sale if it's personal property, okay? There's a provision dealing with financing provisions, and typically in the contract, most contracts are, they pre-print this into it, where basically the offer being made by the buyer, this offer is contingent on financing. In other words, I'll buy your house as long as I can get the loan. But if the lender denies the loan, then you cannot hold me responsible. And so that's what the financing provision does. And if you have to have a loan to buy the property, if you're not paying cash, I suggest you make sure that financing provision stays there, because that's really protection for you. If you're denied the loan, then that's your contingency in order to get out of the contract without penalty. Okay. Then there's a provision dealing with the condition of the property. Now, obviously, this is kind of a twofold provision here, where obviously the seller in most states will have to provide a property condition disclosure statement, which basically identifies all known issues that the seller knows about to the buyer. But this provision does more than just that. This provision is saying that the seller, you agree to maintain this property in its current condition or better all the way through closing. And the reason for that, is it possible at the time we did our due diligence, the day we did our home inspection, whatnot, there were no issues with the house. But then at some point after our due diligence period, but yet before closing actually takes place. Let's say the heating and air unit quits working. Well, the buyer may have no knowledge of that. Because they've already done their inspections, and at the time of the inspections, it was working fine. But now it's not working. Well, is the seller off the hook from having to repair or replace it? No, because you agreed in the contract to maintain this property in the current or better condition. So if something breaks from this point, between this point and closing, then seller, you got to fix that. You got to repair it. You got to make sure that property's in at least as good a condition as it was when they made their offer. Okay. Yeah, and then there's restrictive covenants. As the agent, you need to get a copy of the deed, especially if you're the buyer's agent. But honestly, seller's agent, listing agents, you need to do this as well. But you need to get a copy of the deed. It's all public information. You can get a copy of it and read it. Are there any deed restrictions? Because I will tell you, a lot of times sellers never disclose the fact that there are restrictions on what you can or cannot do with this property. And quite frankly, they don't disclose it because they were never made aware of it. They didn't even know it was there. So y'all get a copy of the deed and make sure there are no restrictions. And if there are restrictions, make sure we know what those are. And obviously we want to make sure the buyer's okay with those restrictions. But in addition to deed restrictions, you got to look at your covenants, your conditions, covenants, and restrictions, especially if you've got a mandatory homeowners association, an HOA. You need to get a copy of those restrictive covenants to make sure that there's nothing in there that the buyer can't live with. I will tell you a very common issue I've seen a lot in the past, where a buyer will buy a house in a subdivision or neighborhood that has an HOA, and then they find out after they move in, they're getting a notification from the HOA, you've got a boat parked in your yard and you're not allowed to have boats anywhere on the property. Well, but I got it behind my fence. You're not allowed to have it on the property. Get it out of here. And you got to get it out of there. And maybe the buyer never even knew that they were not allowed to have a boat, or maybe not allowed to have an RV, or they're only allowed to have a certain number of cars there. I'm telling you, some of these restrictions can be quite burdensome, to say the least. So you better make sure your buyer gets a copy of these deed restrictions, or at least the deed to make sure there are no restrictions, and these covenants and restrictions for these neighborhoods, and make sure they go through it and make sure they have no issues with it before they buy that property.